In this lecture, we're going to focus on legal and ethical issues in human resource analytics. So as a guiding principle, remember this: just because you can, should you? And this applies both to the legal implications and the ethical implications of engaging in HR analytics. So in this lecture, we're going to talk about first legal issues, and then we're going to branch off and talk about ethical issues, which can really fill in that gray area where legal issues still leave us with questions. So let's start with legal issues. So in the United States, we really operate around the idea of equal employment opportunity, or EEO. And this is really a series of laws and guidelines and regulations that target discrimination on the basis of protected characteristics, protected status, protected groups, and so on. Now, this is enforced in the United States by the Equal Employment Opportunity Commission, or the EEOC. Now, this typically applies, most of the EEO laws apply to organizations that have about 15 employees or more, but it will depend on the specific piece of legislation we're talking about. And when we're talking about federal contracts, we typically refer those to the Office of Federal Contract Compliance. Now, in the US, there's been a number of important pieces of congressional legislation. This is not an exhaustive list, but these are some of the key pieces of legislation that have come about over the past 50 or 60 years or so. So starting in 1963, you have the Equal Pay Act, then followed by in 1964, Title VII of the Civil Rights Act. And then following that, you had the Age Discrimination and Employment Act, Rehabilitation Act, the Vietnam-era Veterans Readjustment and Assistance Act, Pregnancy Discrimination Act, Americans with Disability Act, and more recently, the Genetic Information Non-Discrimination Act. And so what each of these acts do, for the most part, is introduce new protected characteristics or circumstances in which employees might experience protections. And so, for instance, with the Civil Rights Act, this is where we saw initial protections in terms of employment discrimination, whether it's in selection, hiring, training, performance management, and so forth, and pay as well, around race, color, as well as sex and national origin, and some other characteristics too. And obviously the Age Discrimination Employment Act is about protecting age, and then some of the other acts focus on protecting people with disabilities, as well as veterans, as well as pregnant women, and more recently, again, that genetic information that is becoming more accessible to us, and now we have all these different websites too, and things like Ancestry.com, 23andMe, where you can actually spit into a vial and get your DNA and some of your genetic information and description of your ancestry and so forth, what type of medical conditions are likely to occur to you within your lifetime and so forth. And so now we have even more sensitive data that are out there. And so this is an important piece of legislation, that being the Genetic Information and Non-Discrimination Act, for starting to address that. Now, interestingly, there's been really relatively few cases, at least in 2017, in terms of the number of EEOC claims regarding genetic information. In fact, the fewest number of claims came from that people falling into that particular characteristic or protected group. The most claims came from people making claims based on race, disability, sex, and age, followed by national origin, religion, color, and then also as a special category, equal pay claims. Now, in the US, we also have what are known as affirmative action plans, and these were introduced by Executive Order 11246, and this was introduced and signed by Lyndon B. Johnson in 1965. And this is required for employers, these affirmative action plans, when it's either imposed by the courts, the EEOC says the company needs to do it, or when that employer is holding a federal subcontract contract of some kind above a certain value. And so these typically involve the organization working with a third party that helps collect the data, analyze the data, and utilization analysis and things like that, and then help make sense of how the organization is working towards its affirmative action goals and so forth. Now, in the United States and more broadly, we can distinguish between two different types of employment discrimination. The first being disparate treatment, the second being disparate impact, which is sometimes called adverse impact. So we talk about disparate treatment, we're talking about intentional forms of discrimination. So for instance, if you're a hiring manager or you know a hiring manager who does not hire women for a software engineering job because they have a stereotype or a bias where they believe women cannot complete that job, that's a form of discrimination that's intentional in nature, and that would likely be characterized as disparate treatment. Now, disparate impact, on the other hand, is a little bit harder to spot. And this is because it's facially neutral. So on the surface, it might not look like it's discriminatory in practice, but it has adverse consequences for different protected groups, or at least one protected group. So one of the first cases that really looked at this, at least at the Supreme Court level, was Griggs versus the Duke Power Company. And in North Carolina, there was a group of African American workers in this power company who were challenged the organization's practice of promoting people based on having a high school diploma and 2 different aptitude tests. They argued, successfully in fact, and the Supreme Court sided with them, that this wasn't really job related. Having a high school diploma wasn't necessary for their particular job, nor were the 2 aptitude tests. And so for that reason, it was resulting in adverse or disparate impact against the protected group of African Americans because they were disproportionately, because white workers and other workers were disproportionately promoted above them. Okay, so that's the major distinction between disparate treatment and disparate impact. Now, in addition, in the United States, we have something called the Uniform Guidelines and Employee Selection Procedures. You can Google this and find this online. It's freely available. And the idea underlying this is it's a set of practices and procedures that organizations can follow. It's really targeted at employee selection, but a lot of these can also be used for performance management, training, and other HR contexts as well. So for instance, in the Uniform Guidelines, they have a section on, well, how do you actually assess disparate impact? And so there's something called the 4/5 rule, the 80% rule. There's also a standard deviation rule one might use too. If you're looking for something that's actually a little bit more rigorous in nature and that actually has a statistical significance test associated with, the chi-square test would be probably a better alternative. But in terms of what the courts recognize most readily, the 4/5 rule is kind of where it's at. Now, keep in mind these uniform guidelines have been around for years, multiple decades now, so they do need to catch up a bit to the times and some of the prevailing research and findings and practices that we have going on today. Now, in addition, in the Uniform Guidelines, you have important information on how to conduct criterion-related validity studies. For instance, if you're trying to validate a selection tool with respect to some type of job outcome, such as job performance, safety, and things like that. It also has guidance around content validity studies and construct validity studies too. And so within this set of guidelines, you can find important information around statistical significance testing, how to use it, and things like that. It's a really, really useful document for organizations to try to follow and adhere to, and it's something that the courts look at. Now, in terms of recommendations when trying to deal with and prevent particular legal issues from occurring, let's work through the different HR analytics project lifecycle phases to understand this better. So starting with data acquisition, make sure you collect data with a purpose. And for that matter, make sure that you also abide by privacy laws and policies too when collecting the data. So make sure that you're aware of any local, state, or federal laws that might have to do with how you store the data, secure the data, and so forth. But in general, it's good, have a purpose, and this is where good question formulation ahead of time can help you really narrow down what are the data you need to collect, and then are they going to be purposeful, and are you only collecting the data you need to collect? That is less responsibility for you because you don't have to collect other things, and also it's less to manage and store too in terms of space, but also you're not collecting things that might be superfluous that really, really shouldn't be collected or maybe are questionable in terms of collecting them. Now, in terms of data management, manage data with a purpose too. So don't just go in and start joining and merging different tables and data frames and so forth. Make sure that you have a purpose in mind. Also abide by privacy laws and policies too in the context of data management. In terms of data analysis, interpretation, and storytelling, analyze the data with a purpose too. Target the analyses to answer the question that you posed originally. It's not always a good idea, particularly when we're looking at things like protected group status and so forth, to just mine the data. You might find spurious correlations or relationships that don't really exist, but they just occurred by chance in the data, especially if the data are not representative in nature. Now, also be sure to understand that anytime you're doing any type of data analysis or creating a statistical or mathematical model or algorithm, that there's going to be bias injected into it. And the bias comes from human beings deciding what factors or variables that go into the model, how the data were collected, what types of tools were developed by humans. And so this bias can actually get propagated throughout the model, and even without you knowing it, and it can actually result in unintended and adverse consequences on the back end, even if you didn't intend to do that. And so make sure that you carefully think about how your data are collected, how you're analyzing the data, how good are your tools, are they high in reliability, are they high in construct validity, and so forth. And make sure that you understand the boundaries of your expertise too when working with more sophisticated types of models and algorithms. Further, be prepared to act on anything that you find, particularly around diversity and inclusion, and particularly around when it involves protected group status. Anything that you analyze and write up could be potentially discoverable in a legal sense. So make sure that if you do analyze something, you're ready to act on it. So if you do find that there is a pronounced pay gap in terms of gender or sex, make sure that you're ready to do something about that. Otherwise, if you don't do something about that and you wrote something up internally within the company, it could be potentially discoverable and used against you in the future in the court of law. Now, in addition, when working with vendors, hopefully you've done your due diligence and understand the expertise of and the credibility associated with these vendors. You understand the product or the service that they're providing. But also remember that the vendor should be an expert and really informed about the tools, services, and products that they're selling to you. And so sometimes, if possible, this is not always possible, it can be more easier said than done, try to obtain some kind of indemnity agreement, which would actually transfer the liability and potential damages to the vendor, assuming that it's something faulty in their product that maybe results in disparate treatment or adverse impact, especially if they're selling you something that involves a black box algorithm or model behind the scenes in which they're declaring that certain factors that go into it are proprietary in nature and they can't disclose to you exactly what the model entails or what the constituent components are. So in those cases, try to absolve yourself from some of the liability, but also do the due diligence too, because it's the right thing to do to make sure that you have a good product or service or tool within your company. Now let's shift gears and think about ethical issues. So starting with the definition of what ethics means in this context, let's define it as the prevailing moral principles and standards that inform action and guide our decision making. So we don't want to just stop at complying with federal, state, and local laws. We want to consider different ethical implications too. Those gray areas around the laws where maybe new advances in technology, data acquisition, and things like that, analytic techniques, the laws haven't quite caught up yet. So ethics are a great way to use those prevailing moral principles and standards in order to help navigate those tricky situations. So in terms of recommendations around ethical issues, make sure that you have clear ethical guidelines within your company. You might need to develop these, and these might need to be HR specific. So what are the guidelines and protocol? And it'll vary depending upon what exactly you're doing. Also, it's important from an ethical standpoint, recognize the boundaries of your expertise. If you're analyzing data and you realize you're getting into some territory where, wow, I don't think I really understand how this particular statistical model works, that might be the time to then either hire someone new, get a contractor, or find a consultant to come in and help finish up that, who has that expertise. So it's really important to pause and say, okay, where have I run up against the boundaries of my expertise? Because pursuing beyond that boundary could be considered unethical. Now also, it's a good practice to aim for transparency, and that's easier said than done, but try to aim for transparency behind the analyses that you're running. So explain to employees why you're collecting data is often a best practice so they understand what the purpose is, how the data are going to be reported, are they only going to be reported in aggregate, and so forth. We also want to make sure that we protect privacy too. So we want to aim for privacy protections from the start. And this could be really part of that first step of developing clear ethical guidelines. Now, we also want to make sure that we analyze, manage, collect, and report the data with a purpose in mind. So not just collecting or analyzing anything we can get our hands on, but really thinking carefully, what is going to serve a purpose, what's going to serve a strategic purpose, as well as what's going to be ethically sound, and what's going to help build trust with our employees, or at least not tarnish trust with our employees. It's also important to really build ethics into the culture of your HR analytics team and your HR department in general. So include ethics as a major point of discussion whenever you're introducing some new technology, acquiring, managing, analyzing, or reporting different people data, or making a decision regarding HR analytics or some new direction that you're going to take. Make sure ethics are at the forefront of that. And then finally, it's important to remember you're dealing with data about humans. And David Green has an article or a blog post about this in which he says this really well. Don't forget the H in HR. It's humans. And so we need to remember that we're talking about data about human beings here. And it's easy to dissociate ourselves from the fact that these data come from people or other humans. And when we do that, we're more likely to ignore certain things of how would I want to be treated if these were my data? How would I want my data to be used? So always take that step back and try to exercise empathy with the data and the people behind those data. Again, as a guiding principle, we want to think both from a legal standpoint and an ethical standpoint. Just because you can, should you? Okay? Just because you can collect those data or acquire those data, should you? Just because you can analyze that and you have access to those data, should you? So think very, very carefully about this at each step of the HR analytics project lifecycle and when you're thinking more strategically about your HR analytics function within your company. So to wrap up, we talked about legal issues and ethical issues in the context of human resource analytics. Thank you very much.